a world where many of our once private conversations take place in the public space of social media. Casual remarks can remain online and accessible for years. Newspaper articles that used to end up in the garbage each night are now Googleable forever. All of this speech takes place in the public domain and is subject to the law. We don't have a right to free speech in Australia. Neil Young explains.
Unlike some other countries, such as the US, we don't have a Bill of Rights. So there is no constitutionally entrenched right to free speech. It is a principle highly valued by the common law. And most statutes are construed with an eye to protecting the right of free speech as a common law value. But it's more a value than a right. We have an implied constitutional freedom to discuss governmental and political matters that the High Court has recognised, but that's a limited area which the Constitution protects. Outside that, many pieces of legislation and common law principles do cut back so-called freedom of speech.
An example of a law that restricts free speech is our Racial Discrimination Act. This law prohibits discriminatory speech, but only in certain settings. A defence could be that the discriminatory speech was fair and accurate reporting in the public interest. After all, reporters need to be able to report on what was said and done. In 2011, the law was tested when Pat Eatock took Andrew Bolt to court. Newspaper columnist Andrew Bolt wrote a story called White is the New Black. He thought that some fair-skinned Aboriginal people identified with their heritage primarily to advance their career. Ron Merkel's legal team successfully showed that Andrew Bolt's columns were both discriminatory and that the defence that it was a fair and accurate report in the public interest did not apply.
What the action was about was two articles which were very cleverly and brilliantly constructed by Andrew Bolt, where he was in effect saying that fair-skinned Aboriginal people have a choice between identifying with their European heritage and the Aboriginal heritage. The effect of the articles was to suggest that they'd chosen to identify as Aboriginal to, in effect, give themselves financial advantage, to feather their nest. The real sting was that they weren't genuine Aborigines, but they were just taking that identification so they'd get better opportunities for education, better opportunities for jobs, better opportunities for advancement. That was the sting of the article. So it was a racially based attack on the individuals who were the subject of the article. What the case established and the evidence established is Aboriginal identity comes about because of your upbringing, who you are, and how you grow into an identity. So you say, I am an Aboriginal person, and without exception, all of the witnesses said, I never chose to be Aboriginal. It was part of my heritage, part of my upbringing. It was never really a question for me. So the central premise of the article, that there was a choice to, in effect, better yourself or feather your nest, was fundamentally wrong. And the whole article, when put under the microscope, which I don't think it was ever expected to be put, showed that it was an article that breached our Race Discrimination Act.
Representing Andrew Bolt was Neil Young. He lost the case, but from the outset, it was a difficult one for him to win. Partly this is to do with the inaccuracies in Bolt's report, but partly also because of the wide scope of the law.
The primary reason why the judge rejected the defence was that Bolt's articles were factually inaccurate, as he found in a number of respects, and secondly, that Bolt had expressed the articles in a way which was somewhat inflammatory, unnecessarily critical, and they weren't expressed in a way which was to minimise the risk of offending people of a particular racial origin.
Neil Young talks about the part of the Racial Discrimination Act that was used in the case.
The group of sections is in fact headed Prohibition of Offensive Behaviour Based on Racial Hatred. So that's the background. The section itself, though, casts a very wide net. It's unlawful for a person to do an act where it's reasonably likely in all the circumstances to offend, insult, humiliate or intimidate another person or group. So it falls as low as offending somebody or insulting somebody. So it's a wide net. It can catch many publications, statements that are offensive or insulting, which have a connection with race, but don't rise to the level of racial hatred or racial vilification of the kind spoken about in the UN Convention. It may be that you need a prohibition that hits a lower register than racial hatred and racial vilification, and it may be humiliating or denigrating a person on grounds of race. But here the connection's even wider. It's reasonably likely to offend somebody, not on grounds of race or using race in the statement, but one of your motivations or reasons for the statement is because of race. So the connections can be a fairly loose one.
Ron Merkel has also thought about the wording of this section, and his ideas differ from Neil Young's.
There's a good argument about whether the law should be looked at and reviewed, but it's not the one that's been out there in the public domain. The real argument is, does speech that is prohibited, is it likely to cause harm in the community? And racial vilification is likely to cause harm. Secondly, is it then appropriately adapted to the legitimate end of trying to prevent harm? And the big argument, which really hasn't been out there, is to prevent this harm, do you wait for vilification to get at the high end, which is direct racial vilification, or do you try and nip it in the bud on the basis that racial vilification must start from comments at a more moderate level that start to stereotype people of a different race and start to build up in the public imagination these people as different or somehow less, and then vilification moves on from one stage at an earlier stage of moderate or modest comment, but stereotyping, and that's how the public start to take a view that these people aren't like us, they're not the same, and therefore they become vilified step by step. So do you nip it in the bud or you wait till it gets to an advanced stage? That's a legitimate debate, but that's not really what the debate's been about.
So what do you think? How do we balance freedom of speech with racial vilification? At what point do we make the speech illegal? Offending, humiliating, or hatred?